You're watching Reality Check. On the day, we've got a landmark judgment about your identity card, the Aadhaar judgment. Supreme Court's 5-judge bench ruled that it didn't, and it wasn't a unanimous judgment. They gave us a 4-1 judgment, meaning one judge called Justice DY Chandrachud disagreed with the majority judges led by Chief Justice of India Dipak Misra when they upheld the constitutional validity of the Aadhaar card and number. 1 billion people have already signed up for it, and the court said that Aadhaar is needed for social schemes. However, what the court did do was that it struck down a very important provision for which you and I have been getting hounded with phone calls and emails and messages. The court said we don't need to link our Aadhaar to our bank accounts or phones or schools or anything else, just with our PAN numbers. They called that provision Section 57, which asked for it as unconstitutional, which means that 87 crore bank accounts that have been linked already because of the incessant bullying of all these authorities, that has been a monumental waste of resources. So that's what the overall judgment is, and immediate impact is for us. But what is the larger picture and nuances of the judgment? For example, when one of the 5 judges, Justice Chandrachud, says Aadhaar is unconstitutional and completely also differs with all the other judges in the main points, thereby becoming a kind of hero for the petitioners, what implication does it really have? He said, you can't regard Aadhaar Act as a money bill. He also said bypassing Rajya Sabha was a fraud on constitution. He said the passing Aadhaar as a money bill is unconstitutional, and Aadhaar as a money bill would qualify it as subterfuge. Once biometrics compromised, it's compromised forever, and Aadhaar is UIDAI's sole authority, takes no onus of data authenticity. Profiling is contrary to privacy. All of this and many other aspects of this huge, almost 1500-page judgment, of which I confess, managed to read only 1/3 of it. And we'll be going through it with the people who know it very, very closely. But first, let's just see some of the reactions that have come in. The government has embraced the judgment as a complete vindication of its policies. The Finance Minister, Arun Jaitley, said, of course, it had to be a money bill. Remember, that had become the sticking point for opposition parties.
It is a 4-1 judgment upholding Aadhaar. In a constitution bench out of 5 honorable judges, 4 have upheld it completely. This is very important. And as Honorable Finance Minister said, this judgment is a judgment of moment. This judgment is a judgment of empowering democracy, good governance, service delivery, and also empowering the ordinary Indian.
यही सुप्रीम कोर्ट ने कहा है, इसी कानून का संशोधन करना पड़ेगा, और जब संशोधन होगा तो वही वित्त मंत्री, वही स्पीकर कहेंगे कि ये मनी बिल है। और मैं आपके सामने ये विश्वास दिलाना चाहता हूं कि जब ऐसी बात होगी, हम कोर्ट जाएंगे और कहेंगे कि जिस तरह से आपने राज्यसभा को दरकिनारे रखा है, जिस तरह से आपने राज्यसभा में डिबेट नहीं होने दी, हम ये नहीं मानेंगे। हम सुप्रीम कोर्ट दोबारा जाएंगे और कहेंगे कि ये जो अमेंडमेंट संशोधन करना चाहते हैं, ये मनी बिल नहीं है। और अगर ये जजमेंट आज जो अदालत ने दी है जजमेंट, ये अगर रास्ते में आती है तो इसको 7 जजेस को रेफर करना चाहिए और जजमेंट को रद्द करना चाहिए।
So the opposition actually claiming the Justice Chandrachud part of the judgment, and the government, of course, going by the majority judgment that has come out. 4 judges against 1. So who's really won? And what about us as citizens, as those that are in villages and need Aadhaar for claiming their subsidies? Have they won? Are their fundamental rights of privacy and life protected or not? We're going to cover all of that over the next half hour, and to help me in doing that, we have lawyer and activist and someone who is, I've been told as well, is the biggest authority on this. Usha Ramanathan joins us in the capital. In studio, we have Zohaib Hussain, who is the lawyer for Aadhaar, UIDAI, And also in studio, we have lawyer for one of the petitioners, Prasanna S. as well. So this first question that comes up, we saw the government saying one thing, the opposition saying something, they both say that they won. And I want to ask you, Usha Ramanathan, as one of the people closely associated with this, you know, when Rahul Gandhi speaks about it, I just want to point out what he said in the tweet. He said, for Congress, Aadhaar was an instrument of empowerment. For the BJP, Aadhaar is a tool of oppression and surveillance. Thank you, Supreme Court, for supporting the Congress and protecting Congress vision and protecting it. So he has said it's a win for them. So who is really right in this, Usha Ramanathan?
You know, the government saying that this is a vindication of what they were saying, that's part of a pattern, because when the privacy judgment came, both Mr. Nilekani and the government said that this is exactly what they had been saying, whereas actually what they'd been saying was that there is no right to privacy at all. We find that in this judgment, actually I feel a little awkward about what the Congress is saying, because the Congress is the one who foisted this on us in the first place, and we kept telling them from 2009 onwards that this was a project that had serious implications, none of which had been considered. I'm just glad that, you know, if today they recognize that this has been a problem, I'm glad that they are finding it finally. Maybe one needs to be in the opposition to be able to see this, but we are happy to have them seeing it, because who knows what will happen tomorrow. The government position that this is a vindication of what they've said, I think that's a bit of a stretch. The position of the government was that money bill is something that they can have declared as a money bill by the speaker, and the speaker's decision cannot be questioned. That's not quite accurate. That's not accurate at all. And both the dissent and the majority have categorically held that there will be judicial review of a money bill. The court has done something that I would not have normally expected any court to do, which is that it has done something like an editorial job on what the parliament has done, what the government has done in parliament. It's, you know, knocked down some provisions, added some things. In small measure, these things happen when you're focused on a clause, but this is like making some changes so that it can become valid as a money bill. That's a bit of a stretch too, so we'll have to see what happens with that.
Okay, so that's a great reality check on both the government and the opposition's claims there for all our viewers, what Usha Ramanathan is saying. So I want to get to the next point, because remember, there's so much to cover in this particular judgment and all the details of it. Now, what's interesting is that there are two aspects about data. Remember, if you've gone through this judgment, and for all of us who followed it, it's all been about what's you know, whether this is becoming a surveillance state or not, whether the Aadhaar allows for people to spy on us or not, and it's been issues about privacy. Now, what's interesting is that while the majority judgment says that it's not, that basically that Aadhaar and is looking after various aspects and taken the security measures, what's interesting is that Justice Chandrachud completely takes a diverging opinion where he says, once biometrics are compromised, it's compromised forever. UIDAI is sole authority and it takes no onus of data authenticity. So do you want to comment on this? That is this just that a minority opinion, that's just his opinion, and that has no implication at all on your clients, which are who you were representing, which is Aadhaar?
Yeah. So firstly, I would like to clarify that as far as the legitimate state aim is concerned of the Aadhaar Act, that is the object that it seeks to serve, that is targeted delivery of subsidies, benefits and services, on that there is a unanimous opinion. Justice Chandrachud in his judgment clarified that I am upholding that this is the legitimate state aim. However, on principles of proportionality, etc., I will go ahead and strike it down. So the aim of the Aadhaar Act to deliver subsidies in a targeted manner. Everyone agrees, okay. And this is not for the purpose of surveillance. So I think we should get that out of the way. Secondly, the fact that there is a possibility of surveillance, and that has been examined in detail by both the majority opinion and the dissenting view of Justice Chandrachud, clarify, and both have taken, in constitutional law there is one settled principle that if you can interpret the law in a manner whereby you can uphold it, then you would do so rather than strike down the entire thing.
Right.
And the majority has chosen to do that, and therefore it has, held that do not retain data for more than 6 months, or it has held that don't retain metadata. So they have tried to uphold the vision of the act while at the same time trimming where it's necessary to uphold the dignity and the privacy of the individuals.
Prasanna, people like you have been tweeting constantly. For a lot of the social media generation, they've got to know a lot by following your tweets. The fact that now the majority judgment says that there really is nothing to worry about. They're very happy with the kind of presentation that was done by Aadhaar and its authorities. What would you say about that? I mean, the Supreme Court has spoken now. We're all safe.
I mean, we need to understand that what was under the lens in this case was the Aadhaar project from its inception to the regime under the Act, etc.
Hasn't the court said quite unequivocally that it's not a surveillance state? That that's not really a problem?
No, that is a little bit of a stretch. As I say, the project was under the lens. If the question is whether it came out unscathed, the answer is a clear no. I'm speaking as a petitioner, somebody who assisted the petitioners here. Of course, there's a huge strong point that we can take from the dissent of Justice Chandrachud's judgment, but also there are a number of positives that we take from the majority opinion.
For example,
on
data,
striking down of Section 57, it's still a huge shot in the arm, primarily because Aadhaar, it's not just the act and the project and the documents, etc.
And for our viewers, I just want to say Section 57 is the linking of Aadhaar to various things like bank accounts and others. Yeah.
And also private usage of Aadhaar.
Right.
For private
companies. Right.
Exactly.
Right.
So there, if you look at the ambition behind Aadhaar, the way in which Aadhaar was conceived as an identity platform,
yeah,
it was the private interest there was always in the back of the mind, which is why in the project they always talked about uniqueness, universality and ubiquity. Both on universality and ubiquity, so the majority judgment, also the dissenting judgment of Justice Dr. Chandrachud, have fairly dealt a body blow. And I kind of agree with what Dr. Usha Ramanathan say when the court has acted like a copy editor, but even in the copy editing that it has done, in striking down Section 57 and in striking down Section 2B, the definition of data to not include metadata in authentication log storage, I think it has sucked out the blood and the flesh of the act, and what remains is the skeleton.
So you're saying the fact that they can't have a data for more than 6 months, that's a major victory?
They cannot store metadata of transactions at all, which was, so Section 8 of the Aadhaar Act, where authentication records were being stored with the UIDAI, that was brought up by the petitioners as an important source of creation of a surveillance state.
Right.
And there it had gone on to say that no, you cannot store metadata. If you do, there is a possibility that
okay, with both of you, I'll take up the issue of some of these instances of data breaches that we were getting and what this judgment says about that. But Usha Ramanathan, the other issue that I want to take up with you, activists like yourself, Jean Dress and others were talking about, and the court also deals with it quite extensively. You all were presenting to the court, this wasn't the right way of Aadhaar wasn't the right way of distributing subsidies, and it seems that the court has rejected that, which is why you have the finance minister today saying that critics of Aadhaar must realize that you can't ignore technology. How do you respond to that, ma'am?
Actually, one of the convenient ways for people to put down what we are saying is by calling us Luddites. And I think I should clarify it even now that in fact one of the petitioners in the case, Bezawada Wilson, is at the forefront of trying to get technology to work and artificial intelligence to work in the cleaning of sewer lines. Now that is something that will help the people of this country. It's a very different thing when we say that personally identifiable information should be allowed to be collected by various people and to be used for various other kinds of purposes like business purposes and surveillance purposes and state control. I think Justice Chandrachud's judgment is, the importance of Justice Chandrachud's judgment is actually twofold. One, it is in keeping with our constitutional history where minority judgments become the basis on which we learn to do the kind of thinking that we need to do when circumstances are changing. Technology is changing the circumstances of power and of the power of people and the power of the state. And that's one of the most important things. And the other thing is that, you know, when we keep talking, saying that, oh, in any case it can't be, you know, it can't be, numbers don't have to be given in different places, we are forgetting that a whole mass of people in this country, who we would broadly call as the poor and the disadvantaged, don't have the luxury that has been given to us, because they've been told by the majority that they have to give the number, and in the event that after they enroll and they give the number and they try their authentication and it doesn't work, then some local authority will do what they need. So I think we are forgetting that there is a whole mass of people in this country who've not had any rights restored to them by this judgment. Instead, we've had the majority tell the government that now you be paternalistic with these people and make sure that, you know, make sure that they get their entitlements. It is no longer being treated as their right. It's being treated like it is largest from the state, which is not what a welfare state is about.